Thank you.
SJC-11181, Commonwealth versus Sarah.
All right, let's proceed. Good morning.
Chief Justice Ireland, members of the court. The defendant's conviction for indecent assault and battery in this case should be reversed for several reasons. The first reason is errors in the handling of first complaint testimony, specifically the admission of second complaint testimony after the first complaint witness had testified through an investigating police officer in this case. Now, there's no dispute from the Commonwealth that, in fact, the police officer in his testimony did repeat the complaint of the complaining witness. Prior to the Commonwealth going down this road in its questioning, the defense attorney objected, and the sidebar was heard. The Commonwealth promised not to go down this road, and they continued to do so anyway.
Could I just ask you a factual question, because I wasn't clear? The complaining witness testified first?
Yes.
And wasn't there cross-examination of her about what she had said to the police officer?
There were questions put to her about what she had said to the police officer. However, there was no impeachment. No prior inconsistent statements were actually admitted because she denied remembering any of her prior statements. So nothing was before the jury at that point of any prior inconsistent statement that she had made in any way.
But I take it the questions were, didn't you say da-da-da-da-da? And she
Those
said,
were
I
the
don't
questions,
remember?
and she said, I don't remember what I said to the police officer. I just don't remember. So there was no evidence before the jury as to any inconsistencies on her part.
Okay.
Now, was there an objection from the defense counsel? I know there was a sidebar afterwards. I couldn't quite tell what that
Certainly.
was.
So what the way that it broke down was there was an objection to the initial question by the Commonwealth when it seemed as if the Commonwealth was going down the road of eliciting a second complaint. The judge instructed the Commonwealth that they could not elicit a second complaint from the police officer. The Commonwealth indicated that it was only going to ask about the general nature of the report, which the judge said, okay. The Commonwealth then proceeded to elicit not only the nature of the report, but where had it occurred and who, in fact, had committed the offense, far beyond what it indicated at sidebar that it would be doing.
But what should the judge have understood to be the general nature of the report, apart from this person did that to me at my friend's house?
The general nature of the report, I would submit, would consist of simply the fact that she reported a sexual assault, not where it was or who had done it. Because once you go beyond that, we're talking really about second complaint testimony.
But is there really a difference? I mean, the jury is there because of the allegation that Mr. Parent committed a sexual assault against this woman at that home. Wouldn't the jury infer precisely that if all she said was, I reported a sexual assault?
There was no other person that, I mean, there was no issue about somebody else having sexually assaulted the young woman, was there?
No. But to be fair, even the general nature of the report, I would contend, was improper second complaint testimony. To that, there was no objection. So obviously, if it's just on that specific area, there's a different standard of review. But the general nature of the report, in and of itself, she reported that she was sexually assaulted, is second complaint testimony. And she went even beyond that, testifying that, in fact, it occurred at the defendant's home and that he had committed the offense. And the Commonwealth, again, doesn't dispute that the officer gave this testimony, but they claim that the testimony was independently admissible for some specific reason. They don't actually cite a hearsay exception in their brief of any particular kind. But they seem to imply that perhaps it was a prior consistent statement that was brought in to rebut the attempt at impeachment that defense counsel had made. But as I pointed out earlier, in fact, this impeachment was simply an attempt. There was no successful impeachment. It was a complete failure of impeachment. No prior inconsistent statements had been put before the jury at the time that the police officer gave his second complaint testimony. So the Commonwealth's reliance on Aviles for the rule that you can bring in a consistent statement once the complaining witness has been impeached, well, simply is inapplicable in this case for that reason. And in addition, at the time that the second complaint testimony was admitted, at the time that second complaint testimony was proffered from the complaining witness to the police officer, the motive to fabricate that the Commonwealth alleges was in existence was still there. So this is not a situation where a prior consistent statement is made before an alleged motive to fabricate is brought out by the defense. But this is a situation where if there was a motive to fabricate, it was still there at the time. So the prior consistent statement rule simply doesn't apply, even if the court believes that there had been an impeachment of the complaining witness. The rule that the Commonwealth is suggesting in this case is that any time there's even an attempt at impeachment of a complaining witness, the Commonwealth is then entitled to bring in the entire statement or the consistent portions of it in an attempt to rebut that, and that simply would swallow the first complaint rule.
Would you agree that if indeed she had answered, not failure of memory, but no, or whatever she answered, but she'd answered it on the merits, the questions put to her, would it be fair game for the Commonwealth to ask these questions?
It would not, because under the rule of prior consistent statements, it's not simply the fact that an impeachment has occurred that then allows you to bring in prior consistent statements, but the prior consistent statement must have been made before the motive to fabricate arose.
Well, besides that rule, I suppose there could be also the fact that, for completion, in other words, they get to have the entire, whatever it is, the whole thing, she said to the police officer, just to put it in context. I mean, there may be a lot of other reasons, independent reasons why it would be admitted, but your real argument is none of those, even if they would apply, they don't here because she professed to a failure of memory.
That's my first argument, is that there simply was no impeachment, so no right of the Commonwealth existed in any way to bring in a prior consistent statement at that point. So there was no independent admissibility of these statements, which is essentially the entirety of the Commonwealth's argument on this point. They don't dispute the fact that it was essentially a second complaint. They simply say that there was independent admissibility, and they cite Aviles, and Aviles does not apply for the reasons that I've said.
Now, on cross-examination, defense counsel tried to question Detective Chalk about statements that the witness had made to him. Yes. Which were purportedly inconsistent with what you testified to at trial.
Yes.
Basis for the judge ruling?
Unclear. The judge ruled that essentially, I think the judge was confused about claiming a present lack of memory as to a fact and claiming a present lack of memory as to a prior statement. The judge interpreted her lack of memory regarding her prior statement as somehow being inconsistent with having the officer testify as to what she actually said, but of course that's not the rule. She certainly remembered the incident that had occurred, and she had made statements to the police officer that were inconsistent with that trial testimony. The defendant should have been entitled to bring in, through the officer, her inconsistent statements that he made to her.
And was a proffer given as to what would have been offered had the judge allowed the testimony?
I'm not sure that a specific proffer was given at the time, Your Honor, but through his attempt at questioning, I think it was quite apparent on the record the lines of questioning he was seeking to admit, specifically about how the assault occurred, when it had been reported. Those were sort of the major inconsistencies.
But specifically, if that testimony had come in, what would the jury have learned that it did not learn?
It would have learned that she had given a different account of how the assault transpired to the investigating police officer. It would have also learned that she would have given a different account as to when she first complained about the underlying assault. And it would have given the jury a different account of specifically who had promised to provide alcohol to who. That was sort of another issue that the defense counsel wanted to explore, as to whether the defendant had promised to provide alcohol or not. And that was important as to...
Was her statement, was it a signed statement, or was it a statement that was included in a police report, quoted in a police report?
It was a statement that the officer had memorialized in a police report.
And was that marked for identification?
It was.
So do we have it?
It would be in the appellate record, yes. It was marked for identification. It was not admitted into evidence, so the jury never knew what these prior inconsistent statements were because the complaining witness claimed a lack of memory as to ever making the statements, and then the judge precluded defense counsel from introducing them through an alternative means, which actually was technically proper.
Was this the area where she had told the police that her friend had woken up and told her father to go away?
That was another area of inconsistency that defense counsel wanted to explore, whether the daughter had woken up at any point prior to or during the alleged assault.
Because she didn't testify to that at trial.
She did not, no. She did not testify.
I don't want
to
to cut off the answer if you're not finished, but I noticed that we're running out of time, and I hope you'll be addressing the procuring and furnishing.
I could certainly turn to that if the court would.
Yes, great, but one other question, you
Yes.
can, after that one, which is the rape shield question, is the one I have. But go to the procuring first.
Certainly, Your Honor. So specifically with regards to the furnishing alcohol to a minor charge, the defendant's conduct, it's undisputed in this case, was that he, in the light most favorable to the Commonwealth, was that he went to a liquor store, bought some alcohol, brought it home into his house, and gave it to his minor child. That's undisputed.
That the delivery happened, if it happened,
In the home.
in the home.
In the home. And the statute exempts providing alcohol in any way to your minor child. It's simply not a crime under the statute. And it's not a crime to procure alcohol for your minor child. What the judge instructed the jury was that they could find that the defendant was guilty of delivering alcohol to his minor child. That interpretation would allow the rule to swallow the exception in this case. Because if you can be guilty of delivering alcohol to your minor child within your home, then the furnishing exception has no meaning whatsoever.
So, but if he had given his daughter the Mike's lemonade while they were still at the store, that would be okay?
That would be procuring, in my interpretation of the statute, would be procuring. The use of the word...
I can't remember, does procuring include one's child or not?
There is an exception for procuring alcohol on behalf of one's own child. That is not criminal under the statute.
What about furnishing?
Furnishing within the home is also not criminal under the
But
statute.
furnishing outside of the home would be a criminal?
Under the definition of the statute, furnishing outside the home, I suppose would not be covered by the exception. They refer to. Excuse me, one moment. Actually, I believe the word furnishing specifically in the statute refers to providing within one's home, and so that the word furnishing implies that the providing occurs within the home in that context. So the judge's instruction essentially allowed the rule to swallow the exception, and given the exception absolutely no meaning. What the defendant did here is undisputed. He provided the alcohol that he had purchased to his minor child within his own home. And as a matter of law, that falls within the furnishing exception. To allow the Commonwealth's interpretation would produce an absurd result, which would be that it's legal to buy alcohol for your minor child, and it's legal to give them some of the alcohol when you're in your house, but it's not legal to yield possession of the alcohol. How those three things could possibly be reconciled is beyond me. I can turn to Justice Botsford's question with my remaining time.
Thank you. Do you think, I guess, what is your response to the judge's conclusion and the Commonwealth's agreeing that the saying anything about the phone call allegedly inviting somebody over for an oral sex was barred by the rape shield law?
Well, obviously, the rape shield law is not an absolute, and in this particular case, what the defense counsel was attempting to introduce was not to prove that the complaining witness was promiscuous or anything about her character, but simply to show that she might have had a motive to fabricate the allegations after being essentially caught making this type of statement over the phone to whoever she was speaking to. So it wasn't being admitted to prove any character for promiscuity or anything of that resort, anything in that regard. And so I think that the judge would have, it would have been appropriate for the judge in that area to, with a limiting instruction to the jury regarding its admissibility, to allow defense counsel to explore that particular area.
Well, your time is up. Thank you.
Thank you.
Good morning, Your Honors. Excuse me. May it please the Court, Ann Pogue Donahue, Assistant District Attorney from Middlesex, on behalf of the Commonwealth. With regard to the alleged multiple complaint testimony, I would suggest that to characterize it as multiple complaint is an incorrect characterization. It was not offered as additional complaint testimony.
Well,
It was.
Well, regardless of whether it was offered as it, is it?
The detective testified that the victim reported that she had been sexually assaulted by the defendant in his home.
Sounds like first complaint testimony to me, or attempting.
But, Your Honor, it was offered to rebut the defendant's attempted impeachment of the victim and claims of fabrication. That was the purpose that the Commonwealth raised at the sidebar after the defendant objected.
But what do you say to the defendant's argument that the impeachment failed because she claimed a lack of memory?
I would say two things in response to that, Your Honor. First, I would say I agree that the victim did not deny making any certain statements to the detective. But that doesn't mean that she was not impeached in other ways. The defendant did raise other issues to give her a bias, from which he argued that she had a bias against him and a motive to fabricate the allegations against him. I would suggest that is still impeachment. That is still possibly successful impeachment.
But why would,
And I would also suggest, Your Honor, that the defendant appears to be trying to have his cake and eat it too, because on the one hand, he's saying that the victim was not impeached with her prior inconsistent statements, and therefore the Commonwealth had no right to rehabilitate her. But on the other hand, he's saying, but he still should have been able to admit statements that she made to the detective as prior inconsistent statements.
okay, but he didn't, so that's where we are. So they
Correct.
didn't come in. And I guess I'm just wondering how those statements would deal with impeachment in other ways, because I think, as the argument has been made, it isn't as though between the time that she spoke to the police and trial or whenever, that something had changed to make it a prior consistent statement, right? In other words, the position in terms of what would the motive to lie would exist when she was speaking to the police just as much as at a later point in time.
I see Your Honor's point, but I would still suggest that at the very least there was no harm here.
But isn't that the essence of the rehabilitation here? Timing is everything in the question of recent fabrication. It's not a question of fabrication; it's a question of recent fabrication. In here, what was the evidence that she had gotten on the witness stand and just made it up now?
I don't think that was the argument, Your Honor. I think the argument was that she had a bias against either the defendant or his then fiancé from around the time of the incident.
So what's the basis then for the admission of this so-called prior consistent statement?
Oh, Your Honor, again, I would just suggest that it was offered to rehabilitate her generally after her impeachment. And I would suggest that there was no harm. It was limited testimony, and the defendant did not object. He did object initially when the judge had a sidebar. The Commonwealth stated that they intended only to gather general information about the report. The defense counsel specifically said that that was fine with him. When the prosecutor returned to questioning, the defendant did not lodge any further objection.
Turning to the inconsistent statements that were not allowed into evidence.
Yes, Your Honor.
Were they inconsistent with her trial testimony?
I would suggest that they were not, Your Honor. And in response to Justice Spina's earlier question, the police report is included in my record appendix at page 14 attached to my brief, to my main brief.
Well, let me ask you more generally. If there are inconsistent statements made by a witness who does not recall what she said to the police officer, which are inconsistent with the trial testimony, are those not admissible?
I think it depends on the circumstances, Your Honor. I think if the...
When would they not be admissible? If she says X at trial and she previously said Y, why would the jury ever be denied the opportunity to learn that she had said Y?
Well, Your Honor, if she denies having made the statement, I would suggest that's clearly inconsistent, and the prior statement should be permitted to come in as impeachment evidence. However, if the witness does not deny making a statement, there's no inconsistency unless there's a finding that the lack of memory is feigned. And here, the judge did not ask.
But you're missing the point as to what it's inconsistent with. It may not be inconsistent with her prior statement that the police officer or that she's reporting, but it may be inconsistent with what she told the jury as to what happened. Isn't that enough?
I'm sorry, Your Honor, could you rephrase
If she
the question?
describes what happened to the jury,
Yes.
and she had earlier described what happened to the police officer, and it was different, would that not be fair game for cross-examination, that when you spoke to the police officer, you gave, or had the police officer say, she gave a different report of what happened than what she told the jury?
Or through the police officer himself.
Well, Your Honors, I would suggest that the previous cases from this court have said that no, unless she denies making the statement or there is a finding by the judge that her lack of memory of making the statement is feigned, then no, it does not come in. There's no inconsistency.
But isn't that when the Commonwealth is seeking to offer it substantively as opposed to the defendant seeking to offer it for the purposes of impeachment? Isn't that the difference?
That had not been my read of the cases, Your Honor.
Cases that are there any cases in which it was the defendant who sought that as opposed to the Commonwealth? I know we have the cases in which the Commonwealth sought to admit it, and then they had the hearsay issue. But if it's being sought to offer purely to impeach and not for its substantive, not for the truth of the matter, I don't know that you stand on strong footing.
And I'm sorry, I don't recall the exact specifics of all the cases that I relied on in my brief.
I mean, certainly in Day, it was the Commonwealth which sought to offer it.
Yes, it was. But I guess I'm not familiar with cases either where this court has permitted the defense to introduce statements that are allegedly prior inconsistent statements where either the witness didn't deny making them or the judge found that a lack of memory was feigned. Neither was the case here. The victim did not deny making the statements, and the defendant did not ask the judge to make a finding that she was feigning her lack of memory.
Could we go on to a different evidentiary point? There was the judge would not let defense counsel put on the fiance's testimony to the effect that she overheard the complaining witness make a cell phone call to a boy, or there was a cell phone call with a boy in which she offered to give the boy oral sex if he came over.
That's correct.
And the judge would not let her testify to that to establish a motive to lie, because apparently the theory was that she would not want her parents to find out what the fiancé had heard.
That's correct.
And the judge excluded that. Now, I don't understand why the judge excluded that.
Well, Your Honor, I would suggest that, well, the judge excluded it on grounds of hearsay and rape shield.
Well, it wasn't being offered for the truth. It was being offered to show motive to lie.
Yes. Well, the defense's theory was that the
Not that she actually would, in fact, perform oral sex. It was being offered to show that she had said that.
Well, I would say two things in response to that, Your Honor. First, I would suggest that the claim that the victim would have been afraid of getting in trouble for that statement does depend on its truth. But secondly,
just that she said it, not that she'd do it.
I understand, but I would suggest that, first of all, there was no basis to come to that conclusion. The defendant's offer of proof was simply that his fiance allegedly overheard this phone conversation and subsequently took the cell phones away from the girls. The fiance did not suggest, either in an affidavit or a voir dire or in any other offer of proof, that the victim was aware that she had specifically overheard this conversation or that the fiance threatened to tell the victim's parents. There's also nothing in the record to indicate that the victim would be afraid of getting in trouble for this statement. And I would suggest that under the circumstances that we had here, this girl brought alcohol over to a friend's house, was freely willing to drink with a man older than her, and as is documented in the record, already had some fairly serious mental health issues. I would suggest that for the defendant to argue that she would have been afraid of getting in trouble from her parents for this statement is entirely speculative, and the judge was not wrong to exclude it, particularly where the defendant's point was to show that the victim allegedly had a bias against him. And he was allowed to do this because the judge did let the fiance testify that she took the phones away from the girls and that they were unhappy about it.
That doesn't have nearly the power of letting the fiancé testify to what she heard.
Well, again, Your Honor, there's simply I would suggest there's no factual basis for the argument that the defendant was making.
Well, that the fiancé was prepared to testify to that.
She was prepared to testify that she overheard a statement, but I would
And
suggest...
as to what the statement was.
And as to what the statement was, but I would suggest that that is too tangential for the argument that he was seeking to build off of that testimony.
And do you think that it is barred by, the conversation is barred by the rape shield law?
Yes. I would argue yes.
How is that a specific act of sexual conduct? Specific instance of to say, come over and I will perform oral sex. Why is that? Is the speech conduct? Is that what you're saying?
An offer to perform oral sex, I would suggest, could be in this circumstance, yes.
Can you turn to the issue of procuring versus delivering?
Yes, Your Honor. So I believe we're in agreement. The statute refers to multiple means of furnishing minor to an alcohol, including furnishing, which is the only one that is actually defined in the statute, procuring and delivering. And delivering is comparable to a sale, and I think that that's an important point in analyzing this statute. And it is clear that there is an own child exception that applies to at least two of these theories, the procuring and the furnishing. But I would suggest that language does not appear in the part of the statute that discusses sale or delivery to a minor.
Don't you think that the language, whoever makes a sale or delivery, you're relying on the very first portion,
Correct.
I take it.
The part that refers to sale and delivery.
Because there are a whole range of ways of making delivery. In fact, they say the first part is sale or delivery, then it's delivery or procures to be delivered. And the second and third parts of it, of that delivery section, seem to refer to establishments. But the first part that you're relying on, whoever makes a sale or delivery of any alcoholic beverage or alcohol to any person under 21 years of age, either for his own use or for the use of his parent or any other person, doesn't that suggest to you that this is not intended to deal with parents selling or delivering?
Not necessarily, Your Honor. I would suggest that if
A parent would be liable for making a sale of or delivery of an alcoholic beverage to his own child, either for his own use, for the child's use, or for the use of the parent who sold it to him?
I think, Your Honor, if the defendant owned a liquor store and his 14-year-old daughter came in and sought to buy a six-pack, that the purpose of the statute is not to allow that to happen. The furnishing exception, the language that discusses
That's not in the home.
The statute doesn't say the home. The statute says premises owned or controlled by the person charged.
So in your example, in the liquor store, the premises would have been owned by the person charged.
Correct.
So maybe the furnishing exception would then apply, if it's not just the home.
Well, I think there are some problems with this statute. I think that the difference between delivering and procuring is hard to parse out. And I think in this case, I would suggest that they are different because, for example, the defendant actually accepted money from the victim to buy alcohol. I would suggest that that's more akin to procuring as opposed to delivering.
But that was,
Of course,
that was
not the daughter.
right.
That was not the daughter.
That was not the daughter, no.
And that's clearly a problem.
Yes, that's clearly a problem. But I would suggest that there have to be some lines somewhere. I don't think that the intent of the legislature was to permit a defendant to walk into a liquor store, buy a bottle of scotch or a case of wine, go home to his house, hand it over to his 14-year-old daughter, and then turn around and walk away and leave her completely unsupervised.
Well, that might be endangering or some other crime, but why isn't it furnishing or procuring?
I would suggest it's delivering, Your Honor. I would suggest that furnishing implies alcohol that's already on the premises, not that has been
Well,
obtained.
as soon as he brought it into the premises, it was already on the premises. I mean, if I go out and buy a bottle of wine and bring it home and serve my 18-year-old, I assume I've bought it, I brought it home, and I've given it to my daughter or son.
Well,
I've delivered it, I suppose, but I've also furnished it after procuring it.
I see Your Honor's point. If there are no further questions, the Commonwealth would rest on its brief and ask this court to affirm. Thank you.